Welcome to Empower You. I'm Dan Reganold. When you come to these Empower You sessions, our goal is simple. We want you to get educated, learn about a few new things, enjoy. We want you to have fun, and we want you to engage in important topics like the topics we're going to talk about tonight, which are liberty and the First Amendment. For those of you who are new, welcome here. We're glad you're here. And if you ever have any question about our classes that we're offering, you can go to empoweryouohio.org to find out what our next classes are that are coming up. I want to introduce you first to we'll call them our virtual team tonight since they're not here. But we've got Betty Overstreet, our executive director, Jill Google, our operations manager, Bill Roll, our treasurer, and Jay Grunke, who's our producer, who's in the studio helping us film tonight. I've got our cousin Willie Popcorn with us tonight since we don't have our studio that Bill Roll can make us popcorn. So we're glad we're here. Also, I want to say thank you to our sponsor tonight, the Godbey Law firms. So with respect to tonight's Empower You giveaway, first I want to share with you that Barb B won the book on Abraham Lincoln leadership at last Thursday night's class. Congrats to Barb. So tonight's giveaway, I don't know, it just seemed kind of appropriate to me. The book 1984 by George Orwell. If you can't find your copy from high school, here's a great chance to read a book with a message that's interesting and timely. So if you would like to be included for a chance to win this book, just go to the Q&A tab at the bottom of the screen. Just take your mouse down to the bottom. It will say Q&A. And just type your email in there, jot me your email address, and that will be your chance to win. So for tonight's suggested reading, our political guru, I've mentioned him a couple times, is Joe Platt. I think Joe knows just about everybody in town, and he's written a new op-ed on why the economy can't take the burden of issue 7. We talked about issue 7 at the last class. Thanks to Joe for this. If you want to read his article, go to empoweryouohio.org, and it's also listed, a link to the article, and it's also listed in the blog section in the right-hand column of the website. Also on tonight's suggested listening tab, if you enjoyed listening to Mike Wilson's class on data, if you're a data person, data-driven person on COVID-19, I really suggest you think about listening to Ben Shapiro's April 19th show. I've been hearing a lot about this guy, Scott Gottlieb, who used to be the head of the FDA. People are starting to call him kind of the shadow coronavirus czar. Ben Shapiro talks to him for about 45 minutes. And this podcast, what it really will do is tell you where this whole thing is going. So I really recommend you listen to that if you have a chance. With respect to our session on last Thursday about China, it was great listening to Al Tufarber from the Tufarber Report. He did a great job. A couple people wrote into me and kind of I had some parallel thoughts that the only thing I really didn't agree with Scott on was this mess with the debt and how many trillions of dollars we may be in the process of adding to it. For those of you who went to our class last semester on the debt, gosh, it just keeps going up. I know we're in a crisis now and I know we need to borrow some money, but at some point, interest rates are going to go back up. And when that happens, if you were at that class, you learned just there's really no way to make everything work. So my message would just be careful. We've just got a class or two left this semester, and I hope you'll join us Thursday. We're going to have Greg Lawson with us, a real friend of Empower You from the Buckeye Institute. He's going to be looking at the state of Ohio's budget and what's going to happen with no money coming in from during this COVID-19 crisis. We talked a couple weeks ago about the hotel authority in Hamilton County and Cincinnati. I got projections that said their hotel tax forecast was less than 50% of what they projected, if that. Greg's got an interesting paper on COVID-19 he's published, and he's going to tell us about what kind of budget cuts we can face in the state. We'll also hear from former District 28 House Representative John Deaver, who will join us to discuss really a tough topic, and that's what it's going to be like if somebody you know loses their home or fights foreclosure or doesn't have a job and has to file bankruptcy. And John will have some tips to hopefully help you avoid that tough task. So if you know somebody who's in that position, please tell them to tune in Thursday night. I don't usually have two suggested reads for the night, but one of our attendees, many of you know him, Mr. Jay Janis, sent this to me. It's an article written by Mark Brown for Cleveland.com. He's the chair of Capital University's law school. And Brown writes, and I quote, "It's not at all clear that Governor DeWine's Department of Health had the authority, or that Amy Acton had the authority to issue orders like those that have been issued in the state of Ohio. Unlike many states, including Wisconsin, Ohio has not chosen to delegate to the governor or the Department of Health emergency powers. And even if Ohio had done so, legitimate questions would emerge over those exercise of powers." With that article kind of as a preface, it's my pleasure to introduce our first guest. Tom Zawistowski is the CEO and founder, with his wife Nanette, of TRZ Communications, a 38-year-old technology company based in Akron, Ohio. In 2009, he was one of the founders of the Portage County Tea Party, for which he became the executive director in 2010. He still holds that position. In 2011, Tom was nominated by Liberty leaders around the state to head a group of volunteers that was challenged, really, with the task of getting liberty-minded citizens together. His We the People convention was held in Columbus on July 4th weekend in 2011. Tom has been recognized as one of the top liberty group leaders in the nation. And really, when I think of liberty in the state of Ohio, there's really one person that I think of, and that is Tom Z. He produces his popular We the People Convention podcast. It's posted every Friday night. And Tom, we're just really glad to have you here to reflect on what's going on around the state of Ohio. And I understand you've been to the protests. Tell me about the protests. Why are they important? Welcome, Tom.
Well, Dan, first of all, thank you so much for this invitation. I've followed, your organization's efforts throughout the years. And what's great about it is that you've been so consistent, no matter what, you've been kept going and providing education. And as we're seeing today, we need as much education as we can get. And so it's just a credit to your organization and Empower You and all the people who've listened over the years. I know you've gotten so much out of it. And the lineup you just talked about, boy, those are the best of the best. And so I'm honored to be here with you tonight for a few minutes and just maybe to take some questions from your participants. I think that, it's important for everyone to understand what's going on at the State House in Columbus. We really are in a situation now where we have to stop this train wreck that is, being foisted upon us by not just our state government, but our federal government. It's pretty clear that the actions they took were, are going to have devastating impact on the economy. And while the intentions were good to save lives, we're actually, probably, costing more lives than we're saving. So why are the protests important? First of all, it is not just a right of Americans to challenge their government. It is a duty. It is your job as a citizen to raise your hand, raise your voice and say, Governor DeWine, why are you doing that? Where did you get your data? Is this true or isn't it true? And the second part of it is that people were so stunned by this that they didn't know what to do. And Dan, I had a lot of people in the media, in politics, who were calling me and who were just really taking the wrong direction. They were saying, our people are sheep. Our people are just taking this. The governor says, I'm closing your schools. You said, okay. The governor says, I'm, taking away your election. You said, okay. The governor says, I'm closing your restaurant. You said, okay. The governor says, you got to stay in your house. You said, okay. You're just a bunch of sheep. You didn't stand up. But I can tell you, because I get phone calls and emails from all over the state every day, that our people didn't just take it. They were angry. They understand liberty. They understand the Constitution and their rights. They just didn't know what to do, Dan. They didn't know how to act out. And so, it was up to myself and people around the state who are considered leaders to try to channel that into something meaningful. And what happened was people just started going to the State House and making signs and making their feelings known. And I was on a phone yesterday with a reporter from Bloomberg, because now the left is repeating the whole Tea Party thing where, oh, we're all funded by the Koch brothers and this is all AstroTurf, which, might have been a little bit true then, but is not true now. And I said to him, listen, I can tell you for a fact, these protests have not been organized. This is real grassroots. All we've done is give people permission. When people called me and said, I want to do something, I said, it's okay. Take your sign, go to the State House, and let your feelings be known. And that is an important part of our American process. And without it, we wouldn't have some of the questions being raised that are being raised now. And so I'm proud of every one of the people that's gone to the State House. I encourage your participants tonight to grab their sign and go there any day of the week, because you'll find fellow patriots there, and let your voices be heard, because that's the only way for us to check the power of our government right now.
Now, what time would you tell somebody to go if they want?
Yeah, generally they're timing it around Governor DeWine's, 2 o'clock non-reality TV show. And so they get showing up at 1 or 1:30 to organize, and then they're generally there until 3. And it's just been a tremendous, if you haven't gone, it's very helpful to you to just see people are like-minded, speaking out and acting out the way they should as American citizens.
So I used the word protest in a comment to someone, and somebody made the comment back like, well, that you're sounding kind of, you're sounding kind of dangerous. I mean, but really the word protest it shouldn't be a bad word, really, just telling your government what you feel like they should do, right?
Well, as I said, it's not just a right, it's a duty. I mean, how do you put anything in check if you're not willing to speak out? And so, the people who are trying to demonize you and say you are putting people in harm's way by not following the government's instructions. Listen, the most important thing, Dan, I want all of your listeners or your participants tonight to understand. We need to kill this false narrative that this coronavirus is the deadliest disease ever known to mankind. That is patently false. It is an absolute lie. And if you're not paying attention, just this last week, the people at Stanford have finally done the testing that you go out and you find out what percentage of the population actually has this disease, so you can then find out what the real death rate is. And surprise, 80 times more people have this disease than the stats that Dr. Acton is telling you. So here's the reality. They are now finding out that this disease is not even as deadly as the regular flu. It is less than 1% deadly. So if you get this, 99.99% of you will not die. But every day.
That's what the Ben Shapiro podcast I told everybody to listen to will confirm exactly what Tom is saying. Now, Tom, is it your feeling after knowing the Ohio Constitution a lot better than me, that the governor and Dr. Acton did not have the authority to do what they've done?
That's exactly right. I mean, particularly the canceling of the election, which I think was actually a criminal conspiracy, because the governor literally admitted to all of us, I don't have the power to do this. Then he went to court, and when the court rejected him, he came up with this plan to cancel the election illegally, because Dr. Acton doesn't have the right to cancel the election either. And for her to say, the night before that every polling location is a dangerous and hazardous place was a political decision, not a medical decision. And I think that's a criminal conspiracy. And so the reality is, yes, they have some rights. And I think if you go to wethepeopleconvention.org, you'll see a little story about Judge Napolitano talking about what rights they do have in an emergency. But they do not have the right to tell you can't assemble, that you can't go to church, that you can't have free speech. Those are constitutionally guaranteed. And the governor has no ability to permanently or for long term to take those away from you.
Now, what's your sense on the Ohio legislature? Surely has the ability with emergency powers to get involved in this. Where have they been? I have not heard a thing from them.
They have been AWOL. It's a disgrace. Think about this. You're just a House member. You're an Ohio House member. And the governor of the state, without talking to you, without ever consulting the legislature, decides that they're going to put hundreds of thousands of people I mean that. Hundreds of thousands in every House district out of a job, and tens of thousands of businesses closed without giving you a reason. And you don't even raise your hand and say, Governor, can I see your data? Governor, can I ask you a few questions when we don't have any cases of this at all? Why you're doing that? None of them did that. This is a constitutional crisis of the highest order, and they are supposed to be our representatives. They haven't represented us at all, except a few of them like Nino Vitale and John Becker and Senator Huffman have individually acted. The legislature has completely let us down.
It's shocking when you read the first paragraph or two of the Ohio Constitution, how clear it is that they should have been involved at this point in time. So I think it's clear that DeWine wants to start getting people back to work, but how are they going to get out of this so that we can resume our lives? You're a small business owner. I'm a small business owner. When are we going to be able to get back to it?
Well, Dan, this is the most important piece. If anyone takes anything away from this conversation tonight, this is what you must take away. President Trump can say, go back to work, go open your business. The governor can say that. But if people are scared to death, Dan, they won't do it. If you think you're going to die, if you go to a restaurant, you're not going to a restaurant. So the problem we have is that President Trump is literally last Friday was calling it a plague. President Trump literally said if we didn't do what we did, people would be dropping in the streets. That's insane. Governor DeWine said last week, this is an invisible monster lurking out there that will kill you. No fear-mongering there. They need to change the narrative to the facts. The facts are, this isn't even as dangerous as the regular flu. You shouldn't be afraid to go out. And that's another reason why you shouldn't be wearing masks, because in your psychology, in your mind, you see masks, you think they're sick. They're not sick. And guess what? Even if you do get sick, it isn't deadly. 80% of the people who get it don't even know they have it, as we just saw in the prisons in Ohio. Dan, did you see the story about the Ohio prisons that we had? 2,000 people had the disease and only 106 of them showed symptoms. This is a very mild disease, highly contagious, very mild. You can't open the company for business, the country for business, if you scare the hell out of people. So everyone on this presentation tonight, you need to start talking to people and let them know this is not that dangerous. You can go out and not be afraid. And I would ask them all to please watch my podcast from last week. Go to wethepeopleconvention.org and watch my podcast, because I think I make a very compelling case for why you should not be afraid, and then share it with others.
And in terms of any other kind of citizen initiatives other than going to Columbus, what else do you recommend? What else do you recommend people do?
Yeah, a couple things that are real important. I'm actually hearing from legislators that they aren't hearing from their constituents. Be driving them nuts. Say, we've got to get back to work. We cannot economically afford this. Number two, and I really mean this, folks, the most important thing we've got to do right now is save our businesses. The head of the Restaurant Association for Ohio just said, I think yesterday, that they are projecting that 40% of the restaurants that are now closed will never reopen. I'm asking you, if you have a fixed income, if you are a government employee that's getting paid 100% salary, if you are even on Social Security and you're living fine on that and that hasn't been cut, if you get your $1,200 check from the government, find a local business and give it to them. We can't have capitalism without businesses. And Dan, you know as better than I, because you're a businessman, people who run businesses don't grow on trees. Our number one job for everyone in this country right now is to save as many businesses as we can, because every business that goes under are going to be jobs that we aren't going to be able to go back to once they lift this insanity.
Well, I think your message tonight really is a great one, Tom. It's similar from one of our guests the other night, just that it's our job to be positive. I've heard the same facts you have, and you're right. It's going to be hard for me when I try to reopen my business with 60 employees to walk in with a face mask on, and instead I need to tell them the facts that as I know them, be positive and understand that we are going to get through this. And we all need to remember that when we're talking to our friends and our neighbors and our associates.
Absolutely right. We're Americans. We've faced difficulties before. We've dug ourselves in a deep hole, but we will dig ourselves out if we can just get the politicians out of our way.
Let's hope. Tom, it's been great seeing you. Thanks so much for just kind of helping us reset a little bit where we're at with our lives in liberty. And would you remind everybody where they can go to listen to your podcast, please?
Yes, please go to wethepeopleconvention.org. And if you go there, right on the front page, you can sign up for my emails as well. Just put your email address in there and you'll start getting those. The podcast is right on the front page. As you said, Dan, I usually post it around noon every Friday. And there's news and opinion in there you won't get anywhere else. I promise you that.
Thank you so much, Tom. Have a good night. Appreciate you joining us.
Everybody enjoy the presentation. Matt's going to do a great job.
So a little bit about our presentation that we're about to go through with Matt Miller-Novak that just is, I think, something interesting that happened last night. So I posted something on Facebook about the First Amendment session with Matt last night, and I went to boost it, which just means to send it out to a few more people. And we wanted to have a lot of people on tonight. And thanks, we got a great crowd tonight. Thanks for joining us. So about 8 o'clock, I sent the post to Facebook, and about 8:15, they told me they rejected it because they said they wouldn't publish a post that involved such a politically charged topic as the First Amendment. So about that kind of ticked me off. I wasn't very happy about it. So I immediately went to Twitter and said, hey, Facebook's won't send out a message about our class on the First Amendment tonight. That was at 9 o'clock. About 9:50 or 10 o'clock, pretty quick, that post was up on Facebook. So Facebook is watching. They're listening. They have a lot of trouble holding back when we try to educate and talk to people about things. But the message is they did, in fact, finally get the post out. With that in mind, I want to introduce you to our guest tonight, Matt Miller-Novak. He's an attorney at the Godbey Law firm. He received his Juris Doctorate from the Chase School of Law, his Master of Fine Arts degree in painting from the University of Cincinnati, and his Bachelor of Fine Arts degree from Youngstown State University up Tom Z's way. Matt first moved to Cincinnati in 2001 to study painting at the University of Cincinnati after marrying his wife, Jamie. Matt soon developed an interest in local government, began involved in campaigns and other community service, and his faith has always driven his desire to empower those with less bargaining power in our society. Matt's now a civil litigator at Godbey Law firm, and he's received his share of coverage in various local news reports on cases, public interest cases, that he continues to grow that practice at the Godbey Law firm. In his private life, Matt continues to paint, as well as play guitar and piano at his church in Walnut Hills. He also serves on his own local government. He remains happily married to Jamie, and he's the proud father of a 12-year-old son. Matt, it's just great to have you tonight. Thanks for joining Empower You, and we're looking forward to your presentation on the First Amendment.
Okay. Thank you. I mean, this is obviously a pretty new experience to me. I'm used to, I used to teach, and I'm used to seeing people. I think the funny thing is about today and using Zoom is that when you're public speaking, you're always told to kind of like make eye contact with somebody in the audience. And I feel like I'm making eye contact with myself and seeing myself judge myself right now already. So it's really kind of awkward, but I'm going to do the best I can in this kind of setting. And I'm going to put up a PowerPoint here, and I'm going to do I hope this works. I did a trial run. So everybody kind of there. It should work. I think that's it. Is it up?
Yeah, you're good.
Okay, great. Perfect. So instead of doing slide view, I'm going to click on the slides. I hope that isn't distracting anybody. A little bit about myself. Like Dan said, I am a civil litigator at Godbey Law. A large part of my practice right now is kind of, I guess, what falls under the blanket of government accountability. And at least that is the part of my practice that I enjoy the most. I really enjoy practicing government law. So I do some First Amendment litigation. I also do some Open Meetings Act stuff. and I do open record stuff. And I think the thing that's kind of interesting on a personal note, you know, I'm actually a very big fan of our government in a sense, at least in terms of the system of our government. And I think when people talk to me, they always assume that I don't like government, and that's not necessarily the case. I actually think we have a great system of government. I mean, the very fact that our government has a system where you can sue our government for doing the wrong thing speaks volumes about it. There are plenty of countries in the world that you cannot sue the government when they do something wrong. And having said that, you know, I think most public servants, is my opinion, are very good people. And unfortunately, sometimes some people get out of hand. They do the wrong thing. They abuse their powers. And I very much see myself as someone whose job it is to work with plaintiffs who have been victims of such abuse, to hold the government accountable, because our government works best when it's held accountable. And that's pretty much what I see my job as a government attorney. So having said that, you know, one thing about being a First Amendment litigator is that, you know, we all have our own personal opinions. You know, we heard Tom's today about a situation, and I could probably listen to a podcast tomorrow that says the complete opposite of what Tom said. And, you know, one thing I've kind of learned as a government attorney that's really exciting about me is that most of my clients, or a lot of my clients, think very differently than I do. And they have things to say that I don't necessarily agree with. And I end up forming very personal relationships with a lot of my clients and learning a lot about why people believe the things they believe. And that's one of the most exciting parts of my practice, is growing as an individual and learning about different people's beliefs and why they truly hold them. And it's really been exciting. So I actually do want to say that to everybody out there. I know I have a couple clients listening, so I'm also trying to score points with them. So let me move forward a little bit here, because every time you give a lecture as an attorney, you're supposed to pull out a good quote. So this is by Justice Brennan in a case called Texas versus Johnson, which is a case where a hippie burnt a American flag and was arrested for it. And this is one of our kind of big free speech cases. And what he says here, and you can read it, but if there's any bedrock principle underlying the First Amendment, that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. And I think ultimately at the core of every First Amendment case, this is kind of it. And the one thing we have to remember about the First Amendment is that it exists. The Constitution, at least the Bill of Rights itself, kind of exists to protect the majority from the minority from the majority. And often when people's First Amendment rights are violated, it's because they're not popular. They're in the minority view of which they are saying them. And sometimes that could be a liberal person in a very conservative area that's being discriminated against, or it could be a conservative person in a very liberal area that's being discriminated against. And, you know, the thing you kind of find in society is that people have a love-hate relationship with the First Amendment, and that's true of many people. We like it when it protects our own speech and our own beliefs, and we tend to sometimes not like it quite so much when it protects someone else's speech, which we find disagreeable. So the First Amendment, when we talk about the First Amendment, you know, just a very simple background, we associate it with the following things, which is the freedom of speech, the freedom of association, the freedom of the press, and the freedom of religion. We're not talking about all these things today. We're focusing on speech. The freedom of speech itself is very veiled, very varied, and there's a lot of topics of which are addressed in constitutional law, whether you're studying it in law school or talking about it on the Facebook. So we've got defamation that comes up often, things like obscenity, fighting words, students and their speech, and public employees. There are certain criminal statutes that have been addressed throughout history, and then public meetings, which we're going to talk about tonight. And I only want to throw these things out here because the right to speak freely is very broad and very general. And what everybody has to understand is that the freedom of speech is not necessarily absolute. You can't necessarily, under the Constitution, Supreme Court precedent, say anything at any time, anywhere. And I think people often feel that way, or they feel like that should be the case. And maybe it should. And, you know, if God was running the show, maybe that would be the case. But we do have a government, and we do have a Constitution. We have a Supreme Court that has interpreted that Constitution over time. And it comes down to, what are you trying to say? Where are you trying to say it? How are you trying to say it? What's the audience? There's many things that kind of vary and impact what you say and how it's regulated. The other thing to mention is that the First Amendment only applies to government actions, and that's pretty important. You know, as a constitutional attorney, you get some calls sometimes from people that get kicked out of a restaurant or something like that because they're swearing at a waitress or something, you know, as an example, or you know, they're removed from some business or something for the way they're acting, and they insist that their First Amendment rights have been infringed upon. Well, the thing to remember is only the government can violate your First Amendment rights. So, for example, if you go into Target and, you know, you're acting crazy, or you're doing performance art where you take off all your clothes, Target can ask you to leave the premises. You're only protected insofar as it is a government action or somebody who is acting under the color of law that is violating your First Amendment rights. And that's an important thing to remember. Okay, I'm going to move that here. So the freedom of speech, I do want a little disclosure here. It is very complex, and all the case law is very fact-based at times. Sometimes it can even depend, I think, on what judge you pull when you file an action. So I do put the disclosure here that I'm only going to teach you enough to be dangerous to yourself and others around you. And I know with a number of people, and I know some people that come to these classes are actually government officials and elected officials. So if you're listening to this, please understand this as an introduction, and always check with your law director before passing any regulations. Don't take my word for it. All right, so when you're addressing the freedom of speech, the most important thing, where the analysis starts, is the forum. Where are you speaking? And the Supreme Court over the years has kind of categorized 3 places. And the first one is the traditional public forum. The second one is the limited public forum. And the third one is the non-public forum. We're going to talk about the second one primarily today, which is limited public forums. I will do a little bit of information about traditional public forums. I'm not going to talk much about non-public forums. And I'll just go ahead and kind of get that out of the way here today. Non-public forums are places like prisons and airport terminals and things like that. And, you know, you don't have much right to speak in there. And the only regulations that tend to be struck down in non-public forums are those that attack viewpoints. And let's just get that out of the way and start with traditional public forums. So traditional public forums are parks, sidewalks, and streets. These are places where human beings in the United States of America have traditionally exchanged ideas since the beginning of this country. You can think of such things as anti-loitering laws that may have come up within the context of traditional public forums. I think Chicago, maybe it was back in the 90s or early 2000s, tried to pass some like anti-loitering laws, which didn't fare very well in the courts. And essentially, these regulations of speech within traditional public forums are subject to what's called strict scrutiny. And the burden is on the government to prove that these restrictions are narrowly tailored to meet a compelling government interest. Any viewpoint-based restriction is unlawful, which you're going to see as a common thread throughout all of this. And it's a very difficult burden for the government to meet. So it is very hard to regulate speech in, let's say, a city park or people who walk down the street. But on the other hand, and this is really what we're here to talk about today, aside from these very traditional areas, we have what are called limited public forums, and sometimes these are called designated public forums. And school board meetings, city council meetings are kind of some very primary examples of this, and this is kind of what we're talking about primarily today and what I've kind of focused my lecture on. There are other designated public forums, let's say on university campuses and things like that. So actually, I'll go back for a second and just mention that, the thing is with limited public forums, they're not necessarily places and circumstances where people traditionally just freely exchange idea. It's kind of the government creates a place for people to speak or a time for people to speak. It's not a park which just sits there where people can speak all the time. It's something that's specifically created by the government for people to speak in a certain context is the best way to think of a limited public forum. So when the government does create a limited public forum, they are allowed to enact what are called time, place, and manner restrictions. And here's some bullet points, and I'll kind of go through them a little bit. But what is a time, place, and manner restriction? Well, let's take a council meeting. There tends to be moments of public participation. There tends to be, that's a time, right? There's a place, which is that meeting. And maybe you have to stand by that podium or be in this area. And manner, you're allowed to talk, but maybe you're not allowed to use a bullhorn when you talk, or crank a foghorn while your city council members are passing legislation. So that's what a time, place, manner restriction is. However, governments may never regulate viewpoints. And that's, again, this is very important because this goes through all freedom of speech issues. You can't discriminate against points of view. Regulations cannot be vague or overly broad. There's this doctrine called overbreadth. So in other words, when we talk about vagueness, if you have rules in your government about time, place, and manner restrictions, they have to have some objective standard. They can't be purely subjective. There has to be something that the public can recognize as an instruction of how to speak to you. Overbreadth kind of refers to, you can have a rule that regulates some unprotected speech, but it's too broad, so it also regulates speech that is protected, therefore is unlawful. Third, governments that have these time, place, and manner restrictions must establish that the restrictions are, number one, content neutral, number two, narrowly tailored, and number three, they must leave open what are called alternative channels of communication. So there are some permissible purposes, and again, this comes into what is a time, place, manner restriction in a government meeting, let's say, whether it's a school board or a city council meeting. Most regulations addressing the length and efficiency of the meeting can be deemed permissible. So if you have public participation, governments can say, hey, we're only going to have 10 speakers a night. A government can create time limits for each speaker and say each speaker can speak for 3 to 5 minutes or something like that. Governments can create time limits for public participation generally. So in other words, the public can't come in and filibuster a local council meeting, and you could say, hey, we're going to have a half hour of public participation. The courts have upheld that. So if 500 people come in, someone's going to lose. Governments can limit speaking to certain times in a meeting. So obviously, you can say that this is a public participation portion of the meeting. And the rest of the time, you're just going to have to be quiet and listen. Governments can ban disruptions to the meetings. So no megaphones are permitted, no foghorns, whatever soccer fans crank and roll around, and Braves fans, I think, used to beat plastic tubes. You can't necessarily bring those into your local council meeting.
Matt, could I ask you a question about that previous slide?
Sure, I'll go back to it. Go ahead.
With respect to governments can regulate the number of speakers. So let's say there's 30 speakers there and they take 15, and for some reason every meeting you just happen not to get chosen. Is there anything more in terms of guidance on that one?
Well, you can't discriminate against viewpoints, and I actually have a slide later on that kind of gives an example of kind of like a copacetic, like regulation. I think if I was advising a government, I would say first come, first serve, right? Speakers can, send in a request to speak, X amount of days ahead of time, first come, first serve. I mean, I don't know if you've been to a local council meeting recently, but aside from like maybe Cincinnati or Cleveland, I mean, most council meetings have like the same 2 or 3 people who want to speak regularly. It tends not to be a problem, honestly, very often. But every now and then a school board is passing a school levy, or there's some moment in time that people are really interested in, and a local council meeting can get flooded. And again, any regulation that is just like content neutral and basically says, hey, first come, first serve, and then essentially you can't say you're being discriminated against if they take the first 10 people and you just, I guess my mom always used to say, you snooze, you lose, right?
Exactly. Thank you.
You're welcome. So limited public forum. So content neutral, and this kind of overlaps with viewpoint discrimination a little bit. So regulations that a government might have cannot attack certain points of view. So a government cannot regulate criticism of itself in a forum. For a long time, and I'll tell you, being a Sixth Circuit First Amendment attorney, I think that I personally feel that some of the laws are a little bit laxed, and I think there's been a history over the last 50 years or so of having some overlap and some public participation regulations that I think are content-based. For instance, the Sixth Circuit Court of Appeals has upheld one regulation that says harassing or frivolous, which I think are content-based in the sense of, one man's frivolous point of view is another man's gold, I think. And I've filed lawsuits that I've won where the opposing attorney called me frivolous. So again, I think it is a matter of content and viewpoint. But having said that, recent Supreme Court opinions, I think, have been pretty awesome regarding the First Amendment. The court, starting with Reed, which I think was decided in 2015, essentially said that, it admitted that there's been some slippage in First Amendment regulation in this kind of limited public forum analysis. And the court kind of has now said that, if you can't decide whether or not speech violates a rule without reading that speech, then it's kind of content-based. That case it applied to political signage, but I believe it would apply to the public meeting analysis, and I'm certainly arguing that in a couple cases now. And there was also a trademark case that for the longest time, trademark regulations had denied what they deemed to be kind of scandalous. So there was a t-shirt company, I believe the case was a t-shirt company, and it was called Fucked, which was F-U-C-T, which was pretty clever, I think. But, you know, otherwise probably deniable under the previous regulation of scandalous speech, where the Supreme Court said, no, man, you know, that no more, that's a content-based regulation, subject to strict scrutiny. And I think the Supreme Court is kind of snapping us back to where we should be. And I don't know what anybody here listening's opinion is of the Supreme Court, but you know, depending who you are, sometimes they get it right, sometimes they get it wrong. And I personally feel like they're getting this right now. So governments, the one thing you have to always remember that they can't regulate silence or silent speech because it's offensive to listeners. So, you know, someone's going to come into a public meeting and say something that's probably going to tick everybody off in there. Everybody that's on the city council is going to be mad. The people listening are going to be mad. Well, deal with it, folks. Governments can potentially limit speech to their business, though. So that's one thing about limited public forums. There's a number of cases that say, hey, if you're a city council, because you want to protect the efficiency and the time of your meeting, you can regulate speech to what you're talking about. So it's a bizarre example, but let's say you go into a city council meeting and say, hey, my mom is mad at me because I didn't show up for Christmas last year. Well, you know, your local council's filling potholes and paying police departments, not dealing with your family drama. So technically speaking, that city council could probably say, hey, man, call your mom. All right. Limited public forums, regulations must be made.
That may not be as outrageous as it sounds, because I've heard some pretty.
I lost you for a second. You kind of dropped out.
Well, your example may not be as wild as it sounds, because I've been to many council meetings where some pretty wild things have been said that didn't really have anything to do with the scope of the city's business.
I've been to my own and heard them, and we let them happen because we don't have many visitors. So, you know, whatever, we let anybody say anything, and we're not, no one's fighting for the mic at our meetings. So we just let people blow off some steam. But yeah, no, I've heard some pretty fun ones too. I haven't heard anybody complain about Christmas though. So limited public forums. So regulations must be narrowly tailored to meet this significant government interest. And what that means is, generally speaking, the government shouldn't restrict more speech than necessary to meet the government, you know, interests. So, you know, even if a regulation's content-based, it can't be like too huge. It's kind of hard to describe this. And honestly, you know, I've had one case that had almost identical facts and had different judges kind of rule on this prong differently. It's a very fact-based analysis, but I can tell you some courts have been saying that, hey, you know, if your big concern is protecting time and efficiency, and your public participation's at the end of your meeting, and you only allow 10 speakers for 3 minutes each, that's enough. So your other regulations don't seem all that narrowly tailored. Other judges I've seen kind of rule differently. So this one's a pretty tough, it's a pretty tough element, and I would never really hang my hat on this one if I was representing somebody. Governments must leave open alternative forms of communication. So in the year 2020, it sounds like those are like never ending, right? Because here we are, not having a public meeting, and you know, maybe 3 months ago, you would have never thought to do this, but now in the year 2020, alternative forms of communication are almost overabundant. But what courts have ruled is that, hey, all right, just because Karen came into a meeting and you didn't let her speak and she could go on her Facebook page and badmouth you, that doesn't mean that that's an appropriate alternative form of communication, because there's always the intended audience. And there's certain people that attend council meetings. There's certain people that watch them, for instance, like the council members themselves. So by saying you can't speak here and say that here, just because you can go and you can say it on your Facebook page, that doesn't necessarily mean that it's an appropriate alternative form of communication. So even if regulations pass this three-part test that I've kind of laid out, you have to understand government still cannot apply them differently to different people. And I think a great example of that is, and I've kind of seen this in my practice, that, hey, every speaker gets 3 minutes. And here's Jack, and Jack has all kinds of good things to say about us. So we just let him speak. But here's John, and John hates us. And every time John speaks, we pull out the stopwatch, you know, and we're gonna be on John. We're gonna watch that clock like a hawk. And as soon as you get 3 minutes, so it's very important that even if your rules are lawful, you cannot apply them disproportionately in a way that is viewpoint discrimination. If you have a rule that says, hey, speakers can't speak more than once, that's probably a fine rule. But you can't let complimentary John speak 3 times and say, Jack, you only get to talk once because you don't have anything nice to say about us and we don't like you. So limited public forums, here's a very common regulation you see. It is all public comments are limited to public participation time. Public participation is limited to 30 minutes at the end of the board meeting. Each speaker who signs in is permitted to have 3 minutes of speaking time, so public participation is limited to 10 speakers per meeting. The first speakers to sign in will receive priority and speak first. To make sure all speakers have an opportunity to address the board, no speaker may speak more than once. There's nothing wrong with that regulation. However, let's say that there's more. What about a rule that states public comments cannot insult individual board members and speakers may not cuss? Well, now you've got a fight. So most certainly I would say that a regulation that says you cannot insult an individual board member is content-based and probably unlawful. I think saying that a speaker cannot cuss, as much as we might disfavor swearing at a city council meeting, certainly I would not do it. I would not necessarily swear here, but at the same point in time, I think the city council would have to deal with that. Here's some common myths, and I'm kind of basing these off of a lot of calls that I get or cases that are not going to be anything. Governments are not required to permit public speaking at public meetings. And that's very important. And that's the point of a limited or designated public forum. There is no law that says that a government, let's say a city council, has to have a public participation portion of any meeting, let alone every meeting. So a lot of times city councils have public participation in their regular meetings, but they don't have public participation in a special meeting. That is entirely lawful. There is no right for the public to speak at any government meeting. 2, governments do not need to answer your questions. A lot of times people get up in public participation, they say, I want an answer to this question. And the government might look at you and say, not going to answer that right now for one reason or another. Maybe not the best thing to do politically speaking, but it's certainly nothing unlawful constitutionally speaking. And a lot of times, the only way you can address governments who won't answer your questions is to not vote for them and encourage other people not to vote for them because they're not very transparent potentially, but that doesn't mean they're violating your constitutional right to free speech. Number 3, government officials are permitted to act like a jerk just like you. So while you might have a First Amendment right to come into a council meeting and be very mean to your council member, they have a First Amendment right to look back at you and say, I don't like you either. And I think a lot of people, they feel like they're being punished, or their First Amendment rights are violated when they go to a council meeting and say, you suck, council member, and the council member looks back at them and says, you suck, citizen. Now, don't get me wrong, I don't think it's politically wise to do that. But at the same point in time, we do live in an era of incivility where everybody tells everybody they suck, so everybody has to deal with that. And that's just part of the thing. It is not a First Amendment violation for your city council member to say that you have a bad attitude. So what happens if your First Amendment rights are actually violated? Well, there is this cool thing. And again, this is why, even if you think your government's terrible, even if your government's mistreating you, some people in our government in the past have empowered you to sue them when they fail. And that's what Section 1983 technically is. It is a United States statute that empowers individuals to sue the government when their rights are being violated. You can get attorney's fees paid because, you know, in my practice, a lot of times people are just being refused the right to speak at a council meeting. They don't have any money damages. So essentially speaking, when they come to me, they're asking me to file a suit to enjoin the government from refusing them the right to put out a political sign or to speak in a public meeting or something like that. Well, I can't take a percentage of their earnings from this lawsuit, like like say a personal injury attorney does. Takes 33 1/3% of the award they get. So what the government has said is that if a plaintiff sues the government to invalidate an unlawful statute, and they do so successfully, the government will have to pay that person's attorney's fees. So that's so attorneys are incentivized to represent people and to spend the 100+ hours you do on a common case and be paid for it if you win. And so people, and to just throw it out there, most of my clients could never afford the work that government attorneys do. And this is what the government has set up. So the government has essentially empowered the people to sue itself and to pay for people to sue itself if they do so successfully, which, you know, at the end of the day, I think is a pretty positive quality of our own government throughout time to do this, to hold itself accountable through the Constitution itself and through things like Section 1983 lawsuits. There is some new territory, and the Facebook problem, I think, is the up and coming issue. I get a lot of calls about Facebook issues, and I can tell you the early cases coming out of the courts right now, the federal courts. Trump himself was sued for blocking people on his Twitter page who were critics. And I think that is kind of the landmark case right now, and that I was out of New York and has been to the appellate court. And I think the thing that you have to look at right now is that, number one, is it a government page or a private page? So, you know, I could be Matt Novak, the council member, and this is my council member page, and this is where I announce all of my legislation. This is where I announce all of my government policies. That is probably a government page, and I could be Matt Miller-Novak, the private individual, where I espouse upon my opinions of local restaurants and pontificate about my theories of the meaning of life. That is my private page. And right now, the court's treating these two things very differently. So if I have a private page and I don't like you, I don't have to associate with you because I have a right to associate with who I choose. So if, you know, and I don't have a government page, and I would probably recommend to every government person not to do that. Let your government entity have a page. And if you're a council member or whatever, you probably should just not do that. It's just too risky. So, you know, my belief is that I have a private page for just friends and stuff like that, and I don't have a government page. I allow my government to have a page. And that's kind of the analysis. And the analysis seems to be treating a government Facebook page, whether it's, let's say, a police force web page or a council web page, they're treating it like a limited public forum in the numerous cases. So essentially, if you are a government actor out there, you know, you have to treat your Facebook page as a government like you would a council meeting with public participation. If you're an individual human being who's not a government actor, and you don't, let's say you have like a book club and you just want to talk about Daniel Steele novels, and some guy keeps coming onto your page and wants to talk about, I don't know, John Grisham, and you're like, get out of here, we don't like John Grisham, you can kick him off, don't worry about it. And Dan, that's kind of about all I have right now, because I kind of figured people would have some questions, and I don't know, I see Q&A and I see 24.
Yeah.
So I think
Well,
I'll be busy answering questions.
some of those were for the big book giveaway, the 1984, but there are some questions. And the first one comes from Tom. And his question was, what are your thoughts about last year's Cincinnati City Council texting issue? Start off with a mild one, right?
It's already been ruled upon. I don't know if it matters what I think. And I think at the end of the day, the only thing that really ultimately matters to a litigator is what the court says that it means. And I think Judge Ruhlman ruled on it. I don't know that the council member thing, if you're talking about the round robin thing, I think it's a little bit more of a open meetings, open records issue,
Right.
The First Amendment issue. I do a lot of open meetings law. I'm very passionate about it. I think transparent government's super important. And I think it was, you know, and honestly, I think it was disappointing. I think it was wrong. But at the same point in time, I also think there was some overblowback. I think what ended up happening is they end up sharing a lot of public records and private text messages from people that weren't actually not public records. So if I was friends with one of the Gang of Five and I just said like, hey man, how's your wife doing? They ended up sharing those text messages, which were not public records because they had nothing to do with government business. So I think it was something that started very badly because you had people conducting government business in these serial meetings, these kind of like, it's playing like musical chairs almost, like, hey, what does Tom think? What does this guy think? What does this guy think? What does this guy think? And it comes to a consensus and a quorum. And I believe that's unlawful. And I've got at least one case right now active that addresses that issue, and I don't like it. But at the same point in time, just because someone's in government and they have a cell phone doesn't mean that their text messages from their mother necessarily are public records. There's always a balance, and there's always things you can look at from two sides of the fence. And I think in that case, I think that Cincinnati council members violated the Open Meetings Act. There's probably no doubt about that. But at the same point in time, then the government ended up sharing a lot of their private text messages from people that had every right to privacy that should not have been shared because it had nothing to do with government business.
Thank you. Rebecca wanted to ask the question, wasn't too happy when DeWine was using my taxpayer dollars to defend free speech zones at University of Cincinnati. Can you address this?
Well, not intimately familiar with it. Can you give me a little bit more information?
This is a new one to me. Rebecca, I'm just going to ask you if you could provide us a little bit more information. Please do. Let me go on to the next one.
Come back to Rebecca.
Yeah, we'll come back to you. It's not uncommon for city councils to use an emergency designation to cause legislation to become law faster or to avoid referendum. This can be legitimate, but sometimes the emergency designation is not justified. Have you ever seen anyone successfully challenge a bogus emergency declaration?
It's very difficult. So I get this call a lot. And it's So yeah, the emergency thing. So what the Supreme Court of Ohio has said, so this one has been ruled upon, that the emergency can be a matter of public policy. So essentially, and again, I don't necessarily endorse any of the things that are going to come out of my mouth. I'm just telling you what courts have ruled upon. I don't know that I even agree with this at all. But what the court has essentially said is that anything that governments essentially declare are an emergency through public policy, so long, and this is more procedural thing, so long as the ordinance or the resolution is actually in the body of the ordinance or resolution, because a lot of governments get lazy and they just put it in the title. They say ordinance 2-2019 and declaring an emergency, blah, 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 blah. And then they have nothing about it, why it's an emergency in the body of the ordinance. But the Supreme Court said is so long as the government identifies what as a public policy it believes is an emergency, that's okay. And if you don't like it, don't vote for them. So the Supreme Court has basically called it a political question, and which underscores a major point. Most of the things you don't like that your government doesn't give you the right to sue them. It's hard to sue the government. Most of the things your government doesn't do that you don't like, your solution to that is to run for government and to run against them, or to support people who are better than them if you believe other people are better than them. And that's what the Supreme Court has said. Again, I don't necessarily agree with that opinion, but that's what they've ruled upon, and that's what governments can do.
This would be a follow-up question to that from Stephanie. Like on an average government that you serve as the advisor to, how often do you actually see residents sue their local government?
Well, I don't advise governments. I advise people who want to sue their government. Okay. So that's probably something to clarify. There's a lot of actions against government. I mean, I couldn't give you the exact numbers, but at the same point in time, I can probably only frame it, in the calls that I get. And I think that maybe of 1 of every 30 people who call me have a claim. Because again, there's a lot of immunity. There's immunity statutes that specifically say that the governments are immune from lawsuits. The states, for instance, are largely immune from suits in federal courts. So there's a lot of protections from the government has from certain lawsuits. So kind of about 1 in every 30 callers that I know that I get actually have a valid lawsuit against the government entity. And I talk to them all, and you figure it out and you go with it. And I don't discourage anybody from calling a government attorney, but it is difficult to sue a government entity, and that's why you should call an experienced attorney.
Could you spend just a minute on slide number 16 from Tom? Tom wanted to see if you could just explain it one more time.
Oh yeah. Well, you can have a rule, right? So every time you have, let's say, a limited government forum, there's 2 things to think about. The one thing is whether or not the law itself, like the regulation itself, is lawful. So you can just write a law that if someone reads that law, you can look at that law and you could say, wow, man, that's unconstitutional as it's written. Sometimes you can look at a law and say, well, that's constitutional. That's fine. That law, there's nothing wrong with that law. But it's applied in a way that is disproportionate. It's applied in a way, you're using it as a shield and a sword, let's say. So for instance, I think I gave the example of the 3-minute time period. So let's imagine you had a law that says, every time someone speaks to us, they only have 3 minutes to speak to us. And let's say every single time someone comes in and says, hey, Dan, I love the work you do on this city council. I love you, man. And they go on a 5-minute love speech about Dan and how great he is, even though they only had 3 minutes, but they're just like, Dan, you're awesome. You're awesome. You're awesome. I love your podcast. I love the things you do. And then some other guy comes up and says, Dan, I don't like anything about you. And you pull out your stopwatch. And what ends up happening is that you let this person speak 3 times to compliment you, and this person only gets to speak once that criticizes you. Does that make sense?
Sure. It does. So your message kind of, okay, Rebecca did get back to me. We'll just take a quick question and then we have to wrap up. A federal court today permanently enjoined the University of Cincinnati's blanket prohibition on student political speech on campus as a violation of the First Amendment. The ruling made by Judge Black of the Cincinnati Division of the Southern District of Ohio paves the way for a likely overhaul of many campus speech policies throughout the state and nation. Any
Well, it
comment?
makes sense. I like Judge Black. I think he's a pretty even-handed guy, and honestly, again, political speech, that's content-based, right? Because that's addressing the content of the speech. It's not based upon a content-neutral time, place, manner restriction. You could say you can only speak in this area at this time in this manner. You can't say that you can speak in this area, this time, in this manner about knitting and stuff like that, or Daniel Steele novels, but you can't speak in this time about how you feel about, let's say, COVID-19, since it's topical.
So your message to people tonight is, if people feel aggrieved by their government, and gosh darn, surely I have at different times, your message is simply call me, email me. Is that the best way to go?
You should call an attorney if you believe that you've been violated, your rights have been violated. You should call an attorney. You should look and do your research and feel comfortable with the person you're calling. But yeah, no, you don't. The one thing I would tell everybody, I think a lot of people who don't have a lot of money are often the ones who are nailed. And that goes, it doesn't matter if you're on the left side of the spectrum or the right side of the spectrum. Poverty and money is not politically biased. A lot of people who are nailed by the government in certain circumstances have varying beliefs, but regardless, just because you don't have a lot of money doesn't mean you can't find an attorney who will represent you. You should call, you should look into it. The law allows that if your case is successful, your attorney's fees can be paid by the government, and a lot of attorneys will take that into consideration when they take your case if it's good enough.
There's nothing worse than having that feeling that the government has done something to you and not be able to express it. And I just urge you all, if you're in that case, to call Matt or someone else and at least get a good hearing on it. Matt, thanks so much for the clear PowerPoint. Can we load that PowerPoint up on empoweruohio.org tomorrow?
I'll email you the PDF, and that way it'll be easier for everybody to download and use.
Excellent. Thank you so much for joining us tonight at Empower You, Matt. Have a good night. Just a couple things left before we send you on your way, everybody. I've got a message from our producer, Jay. Jay just wants to encourage everyone to keep a close watch on our governor and the status of reopening Ohio for businesses. Great damage is being done to individuals and small businesses really everywhere. And finally, I want to thank Tom Z and Matt Miller-Novak for joining us for another great session on liberty and the First Amendment. Before we go, I wanted to just share a story about a empowered young man that was I saw Kristen Hartman over at Channel 9 talk about. If you hadn't seen it, I thought it was a cool story. So this was reported from Lebanon, Ohio by Kristen Hartman at Channel 9. 5-year-old Isaac Cadwalder and his mother, Sarah, they hadn't been seeing much of their neighbors these days like many of us, like me, but they found a way to spread a positive message anyway. The mother-son duo was inspired by a social media post encouraging people across the country to chalk your walk by decorating your neighbors' sidewalks with upbeat pictures and messages. It gives them a little bit of sunshine, a little encouragement, Sarah, Isaac's mom, said in an interview. Isaac was excited to do it. He and his mom wrote on the sidewalk. What they wrote was, "It will be okay." And they referenced a Bible verse, Isaiah 41:10, in multicolored chalk outside his house. The Bible verse he referenced reads, "So do not fear, for I am with you." And then Isaac wrote, "It'll be okay." That's what Isaac said. Our thanks to Isaac and his mom for their important, empowering words. And tonight, my thanks go out to all the liberty-loving people in the great state of Ohio. This one's